number 78, DiLorenzo versus Windermere owners. Counsel?
Yes, I'm sorry. Good afternoon, Your Honor, the court. Mark Bogatin for the plaintiff. For the appellant, I would ask to reserve 2 minutes on rebuttal, please.
You may, sir.
Thank you. The appellate division, in the opinion below, held that a defendant landlord in a rent overcharge case, whether the landlord has obtained a destabilization of an apartment based on a payment of individual apartment improvements, IAI, the appellate division held that the landlord has no obligation under the law to comply with what's referred to as the useful life rule. It's plaintiff's position. We submit that that was wrong. That holding was wrong.
Counselor, are we no longer talking about whether they established that they made repairs in excess of the threshold? Now, we're just talking about whether their deregulation violated the useful life rule.
That's correct, Your Honor. Yes, that is correct. Given the procedural posture of the case, where we are now,
Okay.
obviously it's our position they didn't make enough. But no, that's behind it. That's been litigated. Television ruled that they met that part of their burden, that they did prove that they spent X. Okay.
And so then are we looking at the proof insofar as it related or negated any relation to the earlier repair?
Yes, Your Honor, 100%, 100%.
Okay. And the trial court came to one conclusion, right? And the appellate division came to another, right?
On a question of law, we believe, yes, Your Honor.
Well,
not on a factual
also
matter, on a legal matter.
On the facts of whether they violated they were duplicative of, or they proved that they were not duplicative.
No, we don't agree with that position. We believe the appellate division ruling is very clear. Appellate division ruled as a matter of law that the landlord has no obligation to comply with any useful life schedule.
Well,
it's right in their opinion.
Let's assume we don't agree with you on that. I think that there could be a reading of it to say that what they said was that they didn't have to comply with the schedule that applies to the more general types of improvements. But if we don't agree with you on that, then am I correct that it's a factual difference and that we have to determine which set of facts more comports with what the record is?
Well, if you're looking at, if one is looking at the facts, we believe that there's a total absence and failure of proof on the part of the landlord. The landlord's witness, the property manager, Bagelman, was asked repeatedly, or at least 2 or 3 times, tell us about the prior improvements. He said, I have no idea, no recollection.
I think before you get to that, Judge Stein was trying to ask about the appropriate standard of our review. That is, the trial court made one set of findings, appellate division made an opposite set of findings. Is our standard review to decide which of those is more supported by the record? Or is it a different standard?
I would say, in part, yes, but I don't believe that well, first of all, I don't believe there is any evidence whatsoever introduced by the landlord as to compliance with useful life. On appeal, they're saying that useful life was satisfied or made irrelevant because the prior improvements were washed away. That's their language from their brief. Washed away by a flood. If you look at the evidence in the trial record, there's no testimony by the landlord's witness or anybody else's witness that there was any flood damage to this apartment.
So are we?
I'm sorry?
I'm here, that's okay.
Yes.
So are we then into the legal question of who has the burden of proof?
Of course, I mean, yes, 100%, Your Honor, I certainly agree with that.
But it seems that we can't avoid a factual analysis in deciding this, right?
Well, I would put it a little bit differently, but
Go
I
ahead.
would put it whether or not there's any proof. I think there's an absence and failure of proof. That's our view.
Mm-hmm. And what about the useful life argument that the proof here, that the useful life rule only applies to equipment and furnishings and not to improvements, and that the bulk of these the bulk of this work was characterized as improvement.
Yes, Your Honor. We believe that's the distinction, their distinction without a difference. First of all,
I'm sorry, it's a distinction without a
we would
difference?
characterize that argument, which is their argument, a distinction without a difference.
Well, you know, the problem here is that I'm subjected to a great deal of HGTV. My wife watches it religiously, and as a result of that, from having to stand around and watch HGTV, I've come to understand that furnishings and equipment are characterized much differently than improvements. They aren't all the same thing. And plumbing work, electrical work, that tends to be improvements. Furnishings are the shades. Equipment is the dishwasher. That's the way I understand how those terms of art are used in this setting from my off-the-record experience. Is that your understanding?
Your Honor, no, Your Honor. I
Okay,
believe...
tell me why that isn't correct. That's what I need to understand.
Okay. We believe the state legislature has indicated there's no distinction between equipment and improvements. In the HSTPA, I believe it's the Administrative Code 26-516, I believe is the site. But putting aside the actual site, the legislature says they refer to the useful life of improvements. Landlord has to maintain record useful life of improvements. They didn't say equipment, they didn't say furnishings, they said improvements. At least as far as the legislature is concerned, there's no difference. Equipment is subsumed under improvements. And the same is true of the DHCR. When the actual useful life rule was actually promulgated or enacted by the legislature in '93, I believe, and there's the two-page memorandum from DHCR to the governor at the time, which is included in our brief. DHCR doesn't refer to useful life of equipment, they say useful life of improvements. And I think if you actually look at their argument, my opponent's argument, I think the distinction breaks down, becomes unworkable. They say in their brief that the plumbing invoice for $13,000 is all improvements and not equipment. And they say it's $13,000 charge for labor. They're actually wrong. It's $10,000 for labor, $4,000 for materials. If you talk about plumbing, materials would include, obviously, it's pipes, it's piping, pipes, faucets. That's equipment. I don't know. That's equipment.
So
and obviously, the labor attached to that would fall in the category. I mean, the labor.
Let me get you back to
I'm
Judge
sorry?
Stein's question on the useful life schedule for MCIs and its application, if at all, to the IAIs. So is it your position that the useful lives in that schedule are applicable to IAIs as a mandatory matter, or per the DHCR guidance, when you're dealing with IAIs, it's a more flexible issue? And in answering that question, I just wanted to point out, which I'm sure you know, refrigerators, for example, which people might think of as equipment or appliances, are on the MCI schedule with a useful life.
Your Honor, it's a good, interesting question. I guess if you look at the statute, I guess technically the schedule for the MCI improvements, useful life schedule rather, is technically not incorporated within the useful life rule, which is in the division, provision rather above. It's certainly something the courts can look at, and if you look at the way the courts have applied the useful life rule in the past, they just go to the MCI schedule and apply it towards the IAI rule. But even apart from the MCI schedule, there's no question under IAI, it's in the stabilization code and the stabilization law, landlord has to prove that today's improvement is not within the useful life of yesterday's improvement. There's no question about that. The only question is, well, either
Yes,
you
but
go...
to put a point on my question,
I'm sorry?
to put a point on my question, suppose the useful life in the MCI schedule is 15 years. Could a landlord for an IAI come in to either DHCR or a court and say, I have conclusive proof that the refrigerator in this apartment was non-functioning and the repairs would have cost more than getting a new, so even though it's not 15 years old, I'm still entitled to an IAI. Could they do that?
Certainly, Your Honor, but certainly that just goes to the question of who has the burden of proof. They didn't do it, they didn't even try to do it. Today, in their brief, they say everything, they say that today, it was washed away, it was an emergency situation. There's no proof of that. Oh, also in terms of the plumbing, let's say even the plumbing invoice, the pipes are within the wall. They wouldn't have been washed away by any so-called flood, but bottom line from our point of view is they never introduced a single witness to say this is the case. If they had said, the prior, if they'd said, I think was refrigerator that Your Honor was referring to, if they'd said that, I would be in a different position.
Does
They'd
it
be in a
make
different
any-
position.
Does it make any difference that there were some, you know, to me, the purpose of all of this is so that the landlord doesn't go in and make unnecessary, extravagant improvements so that the rent can be, it can become a luxury apartment or whatever, right? And here, we did have some photographs, and they, as, you know, from what I can tell, they don't show that this was some luxury improvement here. It looks pretty basic. So can that kind of proof corroborate or support an inference that they wouldn't have spent this kind of money if they didn't need to?
You know, our position is no, because, first of all, the photographs don't show you what the condition of the apartment was before they made the improvements in '09. It doesn't tell you the pre-improvement condition of the apartment. And moreover, there are multiple inferences that can be drawn from the fact that they spent supposedly a lot of money. Maybe they want to spend more money to make the apartment marketable. That's possible. Maybe they spent more money, and I'm just suggesting, maybe there were some kickbacks going on. That's an inference you can draw. I'm not saying there were kickbacks, but there's certainly, that's an inference. So I would answer basically no. I don't believe you can tell from the photographs what certainly can't tell from the photographs what the prior improvements were and what the condition of the apartment was before the IAI.
Thank you, counsel. Counsel?
Yes, thank you.
May it please the court, my name is Richard Feldman. I'm appearing for the respondents. Prior to this court's decision in Regina in April of 2020, there was a confusion that existed in terms of the applicability of the 4-year look-back rule and what a rent history was comprised of. This court made it clear under Regina that the absent fraud, which is not present in this case, you can't look back more than 4 years. And an landlord does not have to retain documents beyond 6 years. Here, the lower court made errors of law when I asked to preclude the consideration of the useful life argument for improvements that were done in 1995 and 1998. And again, the action was commenced in 2011, obviously more than 4 years.
But so counsel, the argument you're making then is effectively a landlord can replace anything in an apartment as long as 4 years has gone by, and that's then unquestionable.
The tenant in occupancy
Yeah.
would be the real party in interest, because their rent would have been increased 1/40th of the improvement.
But here there was a vacancy.
Correct. And work was done, and apparently there's no argument that $78,000 in qualified IAI improvements was performed. And the argument now is that work done in 1995 and 1998, as reflected on the rent history, should somehow reduce or eliminate the consideration of
Well,
those.
I'm over here. Sorry.
Yes, I'm
Can you
sorry.
see me there? Okay, that's fair. No, I thought the argument was that the landlord bears the burden of establishing that whatever improvements you make, you can go make them. It's whether or not you can then seek to take this rent out of rent stabilization. That's the whole point. So I thought the argument was to be able to do that, you have to show that the useful life of the prior improvement has expired.
Except for one of...
Do you not understand the law that way? Do you see it a different way?
I see it a different way, Your Honor.
Okay, what is that?
Given the document retention policy under the statute, where landlords only have to retain documents for 6 years.
No, that was not my question.
No, but
No, please.
Sure.
That was not my question. My question is, did you see that requirement under the law? Put aside for the moment how you might establish that. What proof you would have to bring forward to establish that. I'm asking you if you see the law functioning in that way, that those are the requirements that the landlord is subject to.
I believe if it's raised in the pleadings, so it's not a surprise by ambush, so the landlord has an adequate opportunity to research and try to obtain records that are decades old.
Well, wait a second here. First of all, the plaintiff sued for a rent overcharge, right?
Correct.
And you answered. And was there anything in your answer that specified that the deregulation was based on IAIs?
No, we simply,
So how would it become the burden of the plaintiff to plead or establish something, first of all, pre any discovery at all, that they don't even know what it's based on?
so once they start a lawsuit alleging a rent overcharge, and in the complaint, they clearly refer to rent registrations, so they're aware of the increases in rent historically, so they can allege whatever they want. Their records are as available to them as to anyone else, the DHCR records.
So they did put you on notice in the final pretrial,
A
right?
month before the trial,
So, right.
after all
Just-
discovery is complete.
I just want to know if that's true.
Yeah, that's correct.
Okay, so what, if anything, did you do when you saw that? Did you ask to move the trial date, ask for more time to find things, ask to move and eliminate to prevent them from making anything?
The records from the plumber.
You know, I'm asking
No,
if
no,
you
we didn't
did,
do
if
it.
you,
We-
the
we
lawyer,
did not.
did anything.
We did not, Your Honor.
Okay.
We did not.
And did you speak to, at the trial court, anything that you would have or could have done differently in terms of presenting proof had you known earlier? Did you present any arguments to specify what prejudice you suffered as a result of this to the trial court?
I did, Your Honor. On A96 and 97, I objected and also sought to preclude the rent history, and that's A145 and 146.
Yep, and did you talk about how it would prevent you from presenting?
I believe I mentioned the fact that these improvements were so old, 95 and 98, it made it virtually impossible to find witnesses or to get records.
Let me ask you a little differently. You did have some witnesses and some proof regarding these repairs or improvements.
No, we had no witnesses as to the 1995 and 1998 improvements,
Well,
in terms of contractors.
Nobody with personal knowledge, right?
Correct.
You had people that worked for you and could give some general information. Okay.
That, but again, it's an over 400-unit building, rent stabilized, filing DHCR reports since 1984.
So, counsel, let me ask you, I'm over here again.
Yes.
Counsel, let me ask you. So if the schedule says the useful life of a particular improvement is 30 years, what's your understanding of whether or not the landlord then bears a burden to keep documentation for 30 years? Is that the way you see it, or do you see that means nothing? What's the point of it?
I don't know the answer to that, Your Honor. I could see arguments on both sides of that question. There is the 6-year statutory requirement to maintain records. That's clear in the statute. There may be a practical problem in terms of, here you had a sale of the building, so you have that issue that goes along with that and a change of agents. You know, on a certain level, it renders residential properties unmarketable to impose such lengthy record-keeping requirements, especially for records that go back prior to the advent of the computer.
But your
That are in paper only.
But doesn't your argument also entirely wipe out the MCI requirements?
It doesn't, Your Honor.
Well, some of those.
not
some
an
of those-
MCI.
This is not an MCI, this is an IAI.
I understand that, but
Yes.
your argument is that, you're not saying that landlords have a 6-year record retention for IAIs, but 30 years for MCIs.
Just like the Appellate Division First Department held in Fuentes. They said, you know what, if you don't give the tenant the notice when an apartment is deregulated, the remedy is you must give that tenant a rent-stabilized lease. But you can't go back and hit the landlord with rent overcharges, because the document retention policy is statutory, it's limited, 6 years. So in this case,
But then what is, let's try it a different way. What is a tenant to do, since the records would originally be in the landlord's hands? I mean, the tenant, and there might be future tenants, tenant wasn't there when you made the improvement, et cetera, et cetera. What is that tenant to do if you're not going to have these records? And because I thought you said the burden's on them, go find records.
well, I
If you
said-
can't find them because you didn't keep them, how is the tenant going to do that? Or did I misunderstand your argument?
You did not misunderstand it at all, Your Honor. And the problem is, given the passage of time, and here it's decades involving the Windermere, from 1984 onward, and the improvements were done in 95 and 98, and the trials in 2016, what is a landlord
Yeah,
to
but
do?
the law is clear that you cannot, if it's a duplication and the useful life is not expired, again, you can make any improvements you want. No one's saying you can't in that sense, but you can't then use it to try and increase the rent, or take it out of rent stabilization. That's the point. It's not about whether or not you can or can't, and how you would retain your records, or what kind of proof you choose to put forward to carry your burden.
I agree, Your Honor. However, in this case, in this particular case before Your Honors,
Yeah.
the internal cohesion between the various trades in terms of the work performed and the scheduling of the work corroborates the fact that it was a gut renovation and that the entire apartment was done. So if you look at the scheduling of the plumber, which is on 653.
So just to be clear, so this part of your argument is that if there is some burden to carry, you satisfied it because you put forward, if it's not the kind of documents the tenant might argue for, you put forward the kind of testimony and other documentation that carried your burden. Right?
Correct. That shows it's a
Okay.
gut
Fair enough.
renovation, that it was complete, and that to the extent it was caused by water damage, the statute allows under MCI to start a new, to wipe out the old useful life schedules, because the policy is to put these housing accommodations back on the market, not keep them off the market till a stale useful life runs its course. That makes no sense to anyone.
Thank you, counsel. Counsel?
Yes, Your Honor. With regard to the question of proof with regard to the prior improvements and the question of prejudice, apart from the fact they never made a claim of prejudice, and I'll let the record speak for itself. I mean, they never made it, even once we were in the appellate division, they didn't even claim to the appellate division there was prejudice, though the appellate division did find prejudice, at least. But with regard to, with regard to the, they did have within their possession evidence which could have answered this question. What were the prior improvements? The evidence showed that, the law shows that when they made the prior improvements in 95, 98, and took an increase, they're supposed to file a registration statement with the HCR, which says, this is what we spent, this is what we improved. And you have in the record blank registration statements, which they are supposed to fill out.
Where do you see that requirement in the statute or the regs? I mean, I understand the form has space to do that, but where is that requirement to be itemized?
Well, it's on the form. The form is the DHCR form. So the DHCR, by promulgating that form, with the blank is in the record, they're asking them, meaning the landlord, what did you spend? What did you spend it on? The point is, when we filed suit in 2011, the evidence was they had those forms in their possession in that year, 2011, which would have told us what they spent, and they never produced those.
They could have filled the forms
sorry?
out, but they could have also kept receipts and not filled the forms out and still been able to satisfy their burden of proof.
Well, they could
Is
have
that
done,
right?
yes, Your Honor.
Yeah,
They
so
could
it's
have-
not a requirement that they fill the forms out.
Well,
It
they
would
have
have been
to fill the form,
convenient
but-
for them.
I'm
In
sorry.
hindsight, they probably should have, but,
Well,
I
they
mean,
could
can you
have,
point
they
me
could
to a
have
legal,
proven,
can you point me to a legal requirement that they itemize on those forms?
other than the form itself, which is a DHCR form.
Right.
I would just point you to the DHCR form, which requires, administrative agency, DHCR requires them, and certainly they have the authority to do that, to itemize the improvements. They didn't produce those forms. And, to Your Honor, could they have produced invoices? Of course they could have, but they did. And they certainly, their property manager at the time of 95, 98 was a witness for them at the trial in this case. And he said, I don't know about the prior improvements. So I don't see,
But if a witness testifies, I can't remember the whole itemization, here's the total number, but all of that was done in that apartment. all of that was done in that apartment. These are the general types of repairs. No, I can't tell you now to the cent what was done in this room or on this, but all of these repairs, this is the total amount we charged, that's the total amount paid, and it was in that apartment. Is that enough?
Certainly, Your Honor. Certainly, Mr. Begelman, who was the property manager there with us, he could have testified in general terms as to what he did, would have done, most likely did. He didn't even try to do that. He didn't even try. It's their witness, not mine.
So is your position then that their burden is they've got to bring in every tradesperson who did every bit of work to
No,
testify about
no.
what they did in the apartment?
Some evidence, the DHCR form, which they had in their possession when we brought suit, they didn't bring in Mr. Begelman, maybe somebody else, maybe a document. Certainly Mr. Begelman, who was at trial, they could have had him testify in general terms.
Thank you, counsel.
Thank you, Your Honor.